fine. Has Mr. Strickland spoken? Has he spoken to his attorney yet?
No, he hasn't.
Okay. She's in a breakout room with another person, and as soon as she's done with that person, I'll put you in the breakout room with Mr. Strickland. So it'll be a few minutes, okay?
Okay, sir. I just want to let you know he's not consenting to do a video arraignment.
So what is he consenting to do?
I'm getting him his paper. Is there any paper clips or anything?
Oh my God.
Yeah.
Okay.
Can I have? Yeah. Okay. This is the court, sir.
I don't consent to the thing. I'm asking why they can't bring me court.
Okay, hold on. Does he want to speak to an attorney first?
Yeah, well, let's have him speak to an attorney first. You have to speak to an attorney. You have to.
Hold on. Mr. Strickland? Mr. Strickland, can you hear me?
I don't need an attorney.
This is the judge.
Okay, Mr. Strickland,
Open the door.
can you hear me?
Can you hear
Oh,
me?
you don't want to hear me.
Sir, can you hear me?
What?
Mr. Strickland, this is
All right.
Magistrate William Burden. Good morning. I'm going to ask you a few questions. Do you want to speak with an attorney?
Who are you speaking with? The flesh and blood man with a name? Because that's what I'm trying to find out right now, Judge. Who are you speaking with? The name entity or the flesh and blood?
I'm speaking to the person that's talking to me right now.
I am executive of the name entity. That's who you're talking to right now. Do you understand? I am the executor of the name entity. I demand to be released on my own recognizance. I have right here, Judge. You see this, Judge? And then I also have a UCC1 in the name entity. So y'all trying to run a lien on the name, that's illegal. Who are you trying to conversate with? The name entity or the flesh and blood man?
You tell
I demand
me.
to be released on my own recognizance.
No, you're not going to be released today simply because you're insisting on it. The court isn't moved by demands, and the record in front of us doesn't suggest you're handling this situation responsibly. Your claims about estate documents and those paperwork theories don't hold any real legal weight here. Instead of relying on filings that have no practical effect, you may want to reconsider your approach. The court will continue following established procedures, and none of those extra forms are going to change the outcome today.
I have a UCC1 here. I've laid claim to the name entity through the Secretary of State and the federal government. Here it is right here, the Secretary of State, just
Okay. Sir?
it's right here, Lincoln. To the flesh and blood and or the name
Sir, whether I'm talking to the flesh and blood or name entity, I'm talking to both of y'all at the same time. Do either of you want to speak to an attorney?
No, sir.
Okay.
And I don't consent to an attorney. I don't consent to be in no hearing.
Sir, I just asked you one question. I just need one answer.
And I don't consent.
Okay, I know that.
So who are you speaking with? The flesh and blood man or the name entity?
I'm speaking to both of y'all. I'm speaking to both of y'all at the same time. How about that?
You can't.
Now, sir, I know you want me to release you.
Here it is.
Are you gonna let me talk?
Here.
Are you gonna let me talk? Sir?
Sir?
Are you gonna let me talk? I got some questions for you.
I'm here without consent.
Put the paperwork down,
I don't
sir.
consent to this.
I know you don't consent to this. You want the court to release you, is that correct?
Yeah.
Want to release you, the entity, or the person in the flesh? Which one?
Flesh and blood man. I own the entity, so it's going to be released anyway.
All right, now.
For UCC1. everything.
if you don't, when I talk, you listen.
I am.
If you don't want to talk to an attorney and you don't want to be arraigned today, we're going to put you over to tomorrow. You understand that?
So we already been through this. I am the executive of the account.
Okay. Have a good day, sir.
You really have to wonder whether these individuals understand that they are often creating their own problems. This is an arraignment hearing, and if someone truly wants to secure their release, the first step is to actually participate in that process. When a person purposely avoids cooperating, they are essentially choosing to delay their own chance at going home. The system can only move forward if they do. That wraps up the first clip, and the judge did mention the possibility of revisiting the situation the following day, which happens to be today. If anything significant unfolds in court, you can expect a follow-up video covering every detail. But for now, we're shifting over to Magistrate Bree's courtroom, where another self-declared sovereign participant is struggling in a very similar way.
Now calling case number 24W001656. This is the Township of Ypsilanti versus Shannon Phillips.
Hi,
Hi, can you state your name for the record, please?
Shannon Phillips.
Okay, thank you very much. So today is the date and time set for an arraignment in this matter. What I have here is a citation from May 27th of 2024 that charges that on or about that date you did operate a motor vehicle on E-Course Road at or near Harris Road with improper plates. It says that the plate did not come back to the vehicle that it was on. That is a misdemeanor with a maximum penalty of up to 90 days in jail, a $500 fine with court costs, or both. Do you understand all that?
No, I do not understand.
Okay. So let me clarify. When I ask if you understand, what I want to know is, do you know now what you are being charged with, whether or not you agree with it?
No, I do not agree with it. And I filed
Okay.
paperwork to the court
Yes.
expressing that.
Okay, and I'm cutting you off for a second because I'm not asking if you agree with it. I'm just asking. I have explained that you're being charged with having improper plates. Do you understand that that is what you are being charged with? Again, I'm not asking if you agree with it. I just want to make sure, because the purpose of this hearing is to determine whether or not you are competent to stand trial. That's part of it, at least. Do you know what you are being charged with now?
Yeah, I see it on the paper.
That reaction isn't surprising at all. Realistically, what outcome were they expecting when officers gave a direct order to step out of the vehicle and they chose to refuse? In moments like that, the situation only escalates because the person decides to challenge a basic command instead of cooperating. Law enforcement typically follows clear procedures, and ignoring those instructions leaves very little room for smooth resolution. When someone chooses resistance over compliance, the consequences are almost guaranteed to follow, and this case is no exception.
You do have the right to remain silent because anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings. You do not have to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these proceedings would have any effect on your citizenship status. If that does not apply to you, then do not worry about it. So, do you wish to have the public defender speak on your behalf?
No.
Okay. In regards to the misdemeanor charge against you, how are you pleading at this time? Or are you standing mute?
Standing mute.
Okay. I am going to set this for
Um,
a,
Ma'am,
yes.
this has been long and drawn out since, yeah, May. I don't even have that vehicle anymore. Unfortunately, I've had to buy 2 vehicles since that vehicle. Not to mention how aggressive and threatening your officers was when they approached my vehicle. Not to mention they were pulling on my door, yelling and screaming for me to get out or they were going to pull me out.
I actually first came across this segment on Old Squishy Gardener's channel, where they covered the background behind this hearing. The situation they are talking about originally unfolded in Judge Washington's courtroom. The issue was simple but serious. She refused to confirm her identity, just like she's doing again in this Zoom session. Judge Washington, being thorough and following procedure, recorded it as a failure to appear since the court couldn't verify who she was. As a result, a bench warrant was issued to address that non-appearance. It was a straightforward outcome based on her own actions that I'll include a reference to that video in the description if you'd like to check out the full breakdown and see exactly how it played out.
I do have that video on my phone. However, because my laptop is not working, I have to use my phone.
Okay. Before you continue, couple of things. One, I will note that the officers are not court employees, so they are not the court's officers. What I am going to do, because it is the next step in this process, is set you for a pretrial. Okay, the purpose of the hearing today is to make sure that you know what you're being charged with and what the potential penalties are. The next step is a pretrial, which is where you will get to discuss with the judge more of what happened that day, and if you have evidence, then you can bring it up then. Your pretrial is being scheduled for November 27th.
Just a waste of time. 11/27.
Correct. This year, so that's 11/27/2024. That will be at 9 in the morning over Zoom before Judge Washington. Because of your appearance here today, I am recalling the bench warrant that issued for your arrest on October 9th. That bench warrant had issued because of failure to appear for a number of arraignment dates that were set.
But I was there and I have proof of that as well. I was on the hearing. It did the same thing it was doing now, saying that the host was there and would let me in. But I sat there for over like 2 hours on the 9th and the 10th and wasn't let inside the Zoom on either day.
And that brings us to the end of the second hearing. Now we're shifting over to the third one, which takes us back to Judge Washington's courtroom. You'll immediately notice a major change. This time, she's actually using her real name without hesitation. That it's clear she understands that Judge Washington takes courtroom procedures seriously and doesn't entertain unnecessary delays. When someone appears in her courtroom, everything is expected to be handled properly, and the message seems to have finally gotten through.
I do have screenshots of that, so I'll present that as well
Okay.
at the next hearing.
Okay. So, to be clear, the bench warrant is being recalled, so that is going away.
Thank you.
The court is setting a personal recognizance bond, so basically you're promising to appear for the next court date. Again, that's November 27th. I will note that sometimes, depending on the size of the docket, it can take a long time. And I think what was my arraignment docket last Wednesday took 3.5 hours. So it can take a long time. So long as you're seeing the message that the Zoom is still going on and that the host knows you're there and can let you in, then as much as it is not a whole lot of fun, you should wait.
Okay.
Okay. So do you have any questions right now?
Not at the moment. I don't believe so, no.
Okay, thank you. So your next court date again, November 27th, 2024, 9 in the morning over Zoom before Judge Washington.
Okay.
You actually do need legal representation, even if you believe otherwise. Wanting to handle everything on your own is one thing, but understanding the legal system well enough to do it effectively is something completely different. Judge Washington isn't assigning the public defender's office to frustrate you. She's doing it to ensure your rights are protected at every step right now. Your interpretation of the process doesn't match how the law truly works, and that can put you at a serious disadvantage. The judge is simply making sure you have a professional in your corner, someone who can guide you through the real legal procedures instead of the ideas you've picked up from.
All right, the court will call the matter of the Township of Ypsilanti versus Shannon Phillips, 24W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Phillips. Your Honor, when I did speak to Ms. Phillips yesterday, she advised me that she did not want to be represented by the Public Defender's Office. Ms. Phillips, could you say your name, ma'am?
Ms. Phillips, please state your name.
Yes. Shannon Phillips, the natural woman. On the
Okay,
record and for the record, and let the record reflect. Can you guys hear me?
Very
It's saying
loudly.
I have an unstable connection. Okay. Just making sure.
So on October 9th, defendant was found in contempt of court. So that still stands, ma'am. You can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
Was never let in, just like now. But I obviously, I guess it took a minute. You administering the trust without consent?
I'm not going to be.
I'm having a bad connection. It's going in and
I'm
out.
not
I'm
going to
not
be
hearing nothing
releasing
you
the
all are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't
you,
need a public defender, Judge Washington.
That's correct. Civil infractions are not criminal offenses, while criminal charges clearly are. And in this situation, you're not dealing with a simple civil matter at all. You're facing an actual criminal charge. Earlier, right before you were moved into the breakout room, the prosecutor offered you a chance to have that criminal charge reduced to a civil infraction instead. That's a significant opportunity, and it's one that many defendants would be relieved to receive. Accepting that offer could spare you from the much heavier consequences that come with a criminal conviction. If you're looking for the most practical path forward, taking that reduced charge would be a smart decision.
Ma'am, I asked you a simple question and you did not answer the question in a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is
the charges?
You cannot make me have an attorney.
Well, actually I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Right. I will let you do that.
Thank you, Your Honor.
You're welcome.
Traffic infractions are not a crime.
If you had taken a moment to really listen, you would have clearly heard the several times the court explained that there is an offer on the table to reduce your criminal charge to a simple civil infraction. This isn't hidden information. It's been repeated more than once, and it's a genuinely important distinction that a criminal charge carries the possibility of jail time, higher fines, and points added to your driving record, all of which can affect you long-term. A civil infraction, on the other hand, is only a monetary penalty with no criminal consequences attached. The difference is straightforward, and choosing the lighter option could save you from far more serious outcomes.
What will we call the matter of Ypsilanti Township versus Shannon Phillips, case number 24W001656?
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Liebe on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
You have to unmute, ma'am.
Shannon Phillips, the natural woman.
Lebo, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney. Additionally, indicated to me that she is not, at this time, wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, not the
Correct.
criminal infraction. Okay. So, Ms. Phillips, that's correct. You're rejecting that offer.
The offer of what? He didn't offer anything.
Me? Sure, maybe in some upside-down world where everything sensible is labeled as unreasonable. But here in the real world, where the rest of us are operating under actual laws and procedures, your claims simply don't line up with reality. What you're saying doesn't reflect how the legal system works, and it comes across as completely disconnected from the facts that I can see that you're committed to your viewpoint. But the courtroom doesn't run on personal theories. It runs on established rules, evidence, and procedure, none of which support the narrative you're trying to push.
Ms. Phillips, he just told you that he's offering.
Am I not hearing something?
He just told you that he's offering you the civil infraction of expired plate as opposed to the criminal offense of expired plate. One carries
okay, but according to the Supreme Court, traffic infractions are not a crime. The People versus Battle. So what criminal infraction? And I would just like for the case to be dismissed. One, because your who was it, Officer Hannah, and 3 more officers were surrounding my vehicle, pulling my door handles, threatening to pull me out of my vehicle.
Ms. Phillips, I'm going to advise.
I don't even have the vehicle anymore.
Ms. Phillips, I'll take that as a rejection of the offer.
Okay, so what's the offer? I didn't tell him anything.
Mr. Lebo?
Right, y'all just hate to hear the truth. Y'all just want to do what y'all want to do.
Ma'am, if you don't stop yelling out in court, you've already been held in contempt before. I'm going to hold you in contempt and give you 10 days in jail. Do you understand? Mr. Lebo, do you know what your client would want to do?
I do not, Your Honor. I did have a discussion with her, but she did not convey to me a desire to participate in that conversation.
All right. Then if she's not telling you, I will set it for a trial date.
Ms. Phillips, Your Honor, I would perhaps ask the court to consider a competency referral.
Nothing is wrong with me, you all. I am perfectly fine. I can handle my own affairs. Nothing is wrong with
It seems like the problem lies in how the last couple of thought processes are connecting. There's just a clear gap in reasoning. In other words, the way the points you're making link together doesn't quite add up, which makes following your logic very difficult.
I see you're doing so well so far. You're almost going to jail on a traffic offense.
And I do want to know that I did attempt to explain to Ms. Phillips why her understanding of the case law regarding traffic offenses was inaccurate, but that was not a productive conversation.
I could see why it wasn't productive. So I don't know that she meets the level of incompetence to the standard that you're indicating. That if you want a referral because you've talked to her and that's where you are, I will refer her for a competency. If she doesn't participate in that, then she'll be found in contempt or have to go to jail to get it done. So her behavior here today is obviously taking her down a very dark path. Hopefully she can change her mind and do something appropriate. So you either want to have a trial, ma'am, or you want to actually accept an offer. So those are your options.
We could take it to trial. We could take it to trial. We could take it to trial. We could take it to trial.
I heard you when you said it the second time.
Okay, well my screen is saying bad connection, so I'm not sure.
All right, January 8th, not only Elvis's birthday, but a day that reminds us we can celebrate both legendary talent and, well, some truly questionable decisions. Until then, there's plenty more to cover, and we've got a lot of new content coming your way very soon. If you enjoyed this video, give it a like. If not, feel free to hit dislike, but make sure to leave your thoughts in the comments below. Don't forget to subscribe and turn on notifications so you never miss an update. I'm Team Skeptic, and that's it for today. See you in the next one.
Your Honor, perhaps we could adjourn this pretrial and I couldn't attempt to discuss with Ms. Phillips a little bit further in the interim time.
All right, because if she goes to trial and she's unsuccessful, it would be treated like any other criminal matter. So, ma'am, you do understand that you could get up to 90 days in the Washington County Jail, correct?
I hear you.
All right. Retrial will be adjourned to January 8th, 2025 at 10 o'clock a.m. I'm sorry, 9 a.m. Do you have her contact information so you can talk to her so she fully gets what's going on here?
I do, Your Honor, and I would just ask the court if the court could repeat the pretrial date.
I'm sorry, repeat it. January 8th at 9
Thank you, Your Honor.
a.m. Ms. Phillips, we'll see you back here on that date, ma'am.